Hello, everyone, and thank you for joining today's webinar. Before we begin, we'd like to cover a few housekeeping items. At the bottom of your audience console are multiple application widgets. If you have any questions during the webinar, you can click on the Q&A widget and submit a question through the chat box. If we do not get to your question during the webinar, we will follow up with you after the program via email. Additional materials are available in the resource list widget that looks like a red folder at the bottom of your screen. You can find a copy of the program slides there. If you have any technical difficulty, please click on the Help widget. It has a question mark icon and covers common technical issues. Please do note that you can resize or reposition the windows on your screen by clicking and dragging the button in the lower right corner of each window. A recording of today's webinar will be available approximately 1 day after the program and can be accessed using the same audience link that was sent to you earlier. With that, we will start the presentation, and I'll turn it over to Panos.
Thank you very much, Liz. Good afternoon, everybody, and thank you very much for joining us. I am Panos Koutrakos. I'm the EU Law Professor at City Law School, and I'm also the Jean Monnet Professor of EU Law at City Law School. This webinar is organized jointly by the Jean Monnet Chair at City Law School and Reed Smith. In fact, it is part of an initiative that Eve Mellin, a partner at the Brussels office of Reed Smith, raised with me and some other colleagues. We thought that there were certain issues that were central to international trade and topical from a policy point of view, and yet these are often discussed by experts who approach them from a particular, often narrow perspective. And the idea that Eve had, and which we then developed, was to bring together practitioners and academics and policy experts. Their combined perspectives would open up the debate and shed light on issues that are very much open in policy terms. Our first event is about digital trade. One hardly needs to point out its topicality. It is central to the concept of global Britain, whatever that might mean, and we can talk about this later. It has attracted attention in the light of the rollover agreement that the UK has negotiated with Japan. And of course, we are talking about it as the deadline for the negotiations for the agreement on the future relationship between the UK and the EU is painfully close. Is there an opportunity for the UK? May its ambition be matched by the realities of international negotiations and policy making? Is there a clear sense of policy? I can think of no better set of speakers to discuss these and other questions that are raised in this complex field. Let me introduce first our moderator, who is James Lockett, an international lawyer whose international consultancy firm specializes in trade and customs. James's expertise spans a remarkable range of trade and regulatory law and policy issues, and is based on extensive work, not just in Europe, but the United States and Asia. I shall introduce our speakers in the order in which they will take the floor. Our first speaker is Stéphanie Noël, who has an established international trade law practice. Qualified in both Paris and Geneva, she has appeared before various international bodies, including the Court of Justice of the European Union and panels and appellate body of the World Trade Organization. Stéphanie's practice covers a wide range of international trade law issues in different regional and international contexts. Our second speaker is Orla Lynskey, an associate professor at the London School of Economics. She's an expert on data protection, technology regulation, digital rights, and EU law. Her excellent monograph, The Foundations of EU Data Protection Law, published in 2015, has become a point of reference in the area. Our next speaker will be Katalina Bateman, a counsel at the London office of Reed Smith. She practices in intellectual property, technology and data protection law and compliance. She has an extensive experience in a range of issues, pertaining to these areas, such as international transfers of personal data, data management and retention and privacy policies. David Henig will then follow. He's a leading expert on trade policy. He's the director of the UK Trade Policy Project at the European Centre for International Political Economy. He was a civil servant for a long time, first at the Department for Business, Innovation and Skills, and then the Department for International Trade. His regular and illuminating interventions on Twitter have also earned him a large and faithful following of all those keen to keep up with trade law and policy developments. Then we have Sabina Ciofu, who is the head of EU and trade policy at Tech UK. Her policy perspective has been developed over her long stint at the European Parliament, where as a policy advisor, she worked mainly on tech-related legislation on international trade. I'm very grateful to our speakers who have joined us today, and of course to our moderator, James. James, on to you. Thank you.
Well, thank you very much, Panos, and it's a delight to be able to moderate this panel today. It's a fascinating panel, as Panos has introduced, because we have sought to bring together two streams of considerable thought, one being digital trade, which is one of the most topical issues in technology and in trade, and also the Brexit, which is also, from a geopolitical standpoint, presenting us a lot of different issues. So we have an outstanding panel today. I'm very, very grateful to the city for hosting this event. I'm particularly glad that they are, for several years now, a part of the University of London, where I began my own international trade law studies more time ago than I dare to admit. And I'm very grateful as well to Reed Smith, an international law firm that is on the cutting edge of many of these issues as well. So without further ado, I think we will move over to, we're going to bounce around between Geneva and London and Brussels, and I'm in the United States, and we'll make reference to things in Asia. So it is a global webinar with a global perspective, an outstanding panel, as Panos has introduced. So without further ado, let me invite Stéphanie Noël, our good friend from Geneva, to kick off the webinar with her set of thoughts. Stéphanie, over to you.
Thank you very much, James. Hi, everyone. So what I'm going to do is maybe to introduce the topic. I try to keep it short, maybe just 5 minutes, but just to set up the context and set the stage for further discussion. So I do think, because we're talking about Brexit, that what you want to know is how far the UK can go in setting up its own digital trade policy. Now it's an independent WTO member and is able to conclude its own trade agreements. To understand this, I think it's good to provide you an overview of what the legal framework is when it comes to digital trade, just to understand what kind of room for maneuver the UK may have in the context. So as you know, the trade in general depends largely on the flows of information. So I'm not only talking about, the tech industry, but the economy as a whole is supported by the flow of data. This is the case for the traditional e-commerce. So we can talk about that include the trading goods as well. So it can be, companies such as Amazon. Everyone knows about e-commerce. It can also concern trade in digital services that can be delivered online as well, but also other things. It could be, the new tech economy with the applications, big data, the cloud computing. So everything is supported by this free flows of data. And the problem with that is that it's the cross-cutting issue, really. It concerns trading goods as well as trading services, but still, the legal framework is very archaic, if I may say. As you may know, there is this multilateral legal framework, the WTO rules, and which are not fit for the new economy. We have a very old dichotomy between rules on trading goods and rules on trading services. We are not even able, as of today, to determine what digital content is. Is it a good or is it a service? We have very, core provision, including in the General Agreement on Tariff and Trade that concern goods only, on non-discrimination. Are they applicable to digitized content? It's still difficult to know. There is no straightforward answer to this. When it comes to the General Agreement on Trade in Services, same thing. The problem is WTO member need to have made commitment in respect of certain sector in order to liberalize the sector. The problem is it's been made on a positive list approach. So what's not committed, fall outside the scope. So there is no commitment in there. And commitments were made at the time when internet was still in its infancy, on the basis of a classification, on an international classification on services, which predates actually all this new technology as we know them today. So it's still difficult to know if a WTO member has made a commitment or not, even though it's supposed to be totally technology neutral. It means once you have made a commitment, it doesn't matter how you deliver the service. But still, the frontier between what is a new service and a new means of delivery is blurred. It's still difficult to ascertain. Same way, you make commitment in respect of so-called mode of delivery. And when you have something delivered online, it's very difficult to know, actually, is it cross-border, is it consumption abroad? You don't even know what is the mode of supply. And what I would like to say, but we can still maybe discuss this further, or I can take questions, but what I would like to the point I would like to make is that it's very difficult to ascertain what the commitment with respect to data flows are. And so the legal framework is not sufficient today. And so the solution that some WTO member found is to insert chapters containing horizontal provision on digital trade, especially free flows of data. And I think what the United States has proposed, because the US is a very huge proponent of these chapters. It purports to resolve actually all the shortcomings that, as we know them, in the multilateral legal framework. And so now what's happening is that there is increasingly the government are resorting to trade barrier when it comes to data flow, sometimes for legitimate reason. This can be the protection of privacy, consumer protection. So I do think that, my colleagues on this panel are going to address data privacy later on. So this could be legitimate, and the problem is to find a correct balance between the two, between trade liberalization and the protection of some legitimate concerns. So what path the UK is going to follow, I do think, because we can go back to that, it has tabled a proposal for a EU-UK agreement, and it is very much like what the US has proposed in the trade agreement, in the USMCA, and at the time in the TPP. So same thing. Also, I do think we're going to address the UK-Japan trade agreement, and it contains provisions that are quite liberal. And very lately, I think even this week at the WTO, the UK has tabled its first proposal ever in the context of the negotiation the plurilateral negotiation on e-commerce. We do not have it. The document is restricted, but I do think that it actually echoes the UK's proposal in trade agreements on this issue. So I'm not going to be, I'm going to end there. And if you have any question, please.
Well, excellent, Stéphanie. So that sets the stage. As Stéphanie just shared, ladies and gentlemen, the WTO has been locked into this problem that we have analog rules for a digital economy, in essence. The members of the WTO have been struggling to reach agreement on that, which is not yet forthcoming. And so we have a lot of FTAs and so forth. So it's this ground of FTAs and perhaps plurilateral agreements that is really rich space, and we'll explore that in further detail. So Stéphanie, excellent job keying us off. We'll now shift over to Orla Lynskey, who is at the London School of Economics, where decades ago I began my GATT studies. It wasn't even the WTO at the time. So delighted to have a speaker from the LSE. And Orla, we'll kick it over to you, your pivotal work, and how that applies to today. Orla, go ahead, please.
Brilliant. Thank you, James, and thanks to the organisers for having me. So I guess following on from the general context that Stéphanie has just provided, I'm going to talk about something a lot more specific, which is, I think, the regulatory context around data flows, and in particular, personal data flows between the EU and the UK at the end of the transition period. And in particular, to what extent it might be possible to maintain existing personal data flows between the EU and the UK, which I think should also maybe explain the EU's position on personal data flows in the context of broader trade discussions and negotiations. And I think my starting point has to be here to highlight that personal data and its protection for fundamental rights reasons is very much a differentiated regulatory framework within the EU's overall system of legal protection. And I think this is very nicely summed up by the German jurist Spiro Simitis around the time the GATS was being negotiated, where he kind of said, we're not talking about bananas here. And that is very much, I think, the starting point for the EU's position when it comes to personal data. And the reason for this is that if you look to the EU's Charter of Fundamental Rights, which is a primary law document, so kind of constitutional significance, I hesitate to ever use the word constitutional in the EU context, but, of the highest legal significance, you see there that the EU singles out not simply a right to privacy or a right to respect for private life, but in addition, in the first of its kind at international level, a right to respect for data protection. And so this kind of sets data protection up on a pedestal as something that is protected within the EU legal order as a fundamental right. And this wasn't the case at the time when the EU's first regulatory framework for personal data protection was enacted in 1995. But in the interim, so since the Charter entered into force in 2009, and since a new regulatory framework, the GDPR, was enacted in 2016, what we see is the EU's focus here shift very much away from data liberalisation as a core kind of tenet of EU data protection policy, or as the primary tenet, I would say, of EU data protection policy, to fundamental rights taking centre stage. And so if you look at the GDPR now, you still see that this legislative instrument has kind of twofold aims: to ensure the free flow of personal data, but always in the context of protecting fundamental rights. And so as a result, this, I think, complicates the EU's perspective when it goes to negotiate elements of trade agreements that concern personal data. And so what I want to kind of briefly outline here is that not only do we have a kind of specific legislative context within the EU, or specific legislative provisions that apply to cross-border data flows, but also accompanying that, we have a very strict line of case law from the European Court of Justice, which is anchored in and kind of uses this right to respect for data protection in the EU Charter in order to essentially, I would say, tie the hands of the EU institutions when it comes to negotiating about data protection on an international stage. So, briefly, how does this work in practice? Well, if you look at the GDPR, like its predecessor, you see that in order to allow for data flows from within the EU to outside of the EU, so the UK in a few weeks' time, the country to which the personal data are transferred has to offer an adequate level of protection. So first thing to note about this is that in key jurisprudence, so the Schrems 1 case, adequate was interpreted to mean essentially equivalent protection to that offered by the EU. So the standard for assessment here was very much raised. And then secondly, adequacy isn't a kind of a static assessment at any one particular time. It's a dynamic assessment, which means that a state or a sector within a state could be recognised as adequate at a particular point in time, but that recognition of adequacy could be revoked. And so, that's the kind of overarching question. Does the third country, the non-EU state, offer an adequate level of protection? And here we might say, if we kind of took that and applied it to the UK context, you would say, well, the UK has enacted the GDPR. At the moment, we have substantially almost identical levels of protection between the UK and the rest of Europe. What is there to stand in the way of an adequacy assessment or an adequacy finding on the European Commission's part? Because it's the European Commission that makes this assessment. Well, I think at the moment that's probably a kind of a valid starting point. However, there are a number of risk factors, I would say, for adequacy that we can already identify. So, for instance, the UK has introduced a piece of legislation that suggests that at the end of the transition period, there will be a new UK GDPR, so not controversial in and of itself. But there are provisions in there that are likely to raise eyebrows. So, for instance, that the Secretary of State can recognise third countries as adequate or revoke those adequacy findings, which essentially politicises the adequacy assessment in a way that I think would be unacceptable from an EU perspective. And there are other kind of red flags we could possibly talk about. So I would say that it's by no means a given that the UK will be recognised as adequate by the European Commission. And even if it does, that finding of adequacy would be upheld by the Court of Justice of the EU. So in the alternative, or in the absence of that kind of adequacy finding, companies or data exporters can rely on contractual mechanisms. So standard clauses, binding corporate rules. I think my colleague's going to talk about this afterwards. But just to say there that, again, following a recent judgment in July, the Court of Justice of the EU has said that even where you're relying on these contractual mechanisms as a data exporter, you need to look at the overall picture in a non-EU state to see whether or not adequate protection is offered. And this includes factors like the national security situation in a non-EU state. So it's a very difficult assessment for a kind of a data exporter to make. If I transfer my data from Germany to Mexico, to what extent will the intelligence services in Mexico be able to access that data in a way that violates European privacy and data protection rights? Good luck, basically. So you can see that there are at least some kind of claims that this amounts to a de facto data localization regime. And so I guess some questions, and I am by no means a trade lawyer, but this has been kind of labelled, at least, as protectionist. However, maybe one thing to note is that this regime is equally stringent within the EU as for those outside the EU. So it doesn't seem to be kind of discriminatory in any way. And we also have an exception in the GATS for privacy and data protection. So the EU is, in theory, able, I think, to follow this approach. Another thing, or another question maybe for us to discuss today, is whether then it is in the UK's interest to align to this data protection framework. or whether, we might see another block of states emerge who start to move away from data protection as a fundamental right, or that fundamental rights vision of data protection, and simply consider personal data from an economic perspective. And here, I think when you look at this globally, what you see are kind of two different approaches to data protection law. One very much rights-based, kind of spearheaded by the EU and the Council of Europe, with a lot of non-European states signing up to these models, and another very much more economic approach, I would say, with the kind of archetypal example there being the APEC privacy framework. And so I think there will be a choice here at some point for the UK as to which route it wants to go down. But I look forward to the discussion.
So thank you very much, Orla. I think that has given us, an excellent perspective in the issue itself of data protection. So thank you very much for that. And we'll come back to that and invite you to talk about how that fits more into the broader trade setting. We've seen the big picture and we've seen the issue picture. Now let's find out from Katalina Bateman of Reed Smith in London what it looks like from a client standpoint. So Katalina represents a number of clients. They may be global, they may be European, they may be UK based. And Katalina, could you unwrap for us from your perspective how this is looking and what the expectations of your clients might be? Thank you.
Sure, thank you, James. Perhaps I come back to the title of this webinar is and whether the UK could deliver a Silicon-upon-Avon. The UK has a long tradition of innovation and being a preferred hub for international commerce. I think the UK is uniquely placed, including after Brexit, to continue being a forerunner on digital transformation. And we see this at Reed Smith with the many ambitious and innovative projects that our clients come to us for legal advice on. And I think there are plenty of reasons why we should continue seeing growth and development of tech businesses in the UK. We have skills, location, language, good access to finance, but also the laws of England and Wales in particular. They've been long preferred choice of governing law for commercial cross-border contracts, as well as the English courts as the preferred jurisdiction for resolving disputes. And there are a number of factors for that. Our laws are generally well known, understood by businesses globally. They're flexible enough to allow courts to deal with unexpected situations. So that ensures a relatively high degree of certainty and stability. And our laws are also based on the core principle of the freedom of contract, which ensures that contracts are interpreted in their commercial context. So I do believe that there will be a continuation and a number of factors in the UK's favour to help achieve these ambitions of seeing the UK tech industry as a global player, which should be welcome news to those of our clients with UK-focused operations. But equally, this then makes me think about that famous John Donne phrase, that no man is an island, the idea that we do badly when isolated from others, and the need to be part of a community in order to thrive, because this continues to be an ever-globalized world, and technology is a pivotal driver of that. I then start to think about the vast majority of our own clients and multinational organizations, and many of them that are offering goods or services that are either technology-related or technology-dependent. And they offer them across numerous jurisdictions that will invariably involve the processing and the transfer, in particular of personal data, which is so highly regulated as Orla has demonstrated. And these organizations, these businesses will look to ensure compliance with data protection, privacy, cybersecurity laws across a broad range of countries. And so obviously the aim when you approach one of those projects where you're trying to launch a product or service across a number of jurisdictions, it's let's try and develop a framework that is as holistic as possible meets as many of these countries' requirements as possible to then, not to have too many variables between them. And so coming to Brexit, what could this mean if the UK is an outlier in terms of what our laws will look like after the end of the transition period? Will these organisations have to modify their existing compliance framework as a result of differing regulations or standards in the UK? Will they have to implement additional compliance actions to transfer personal data, in particular to the UK? And could that be a roadblock in achieving Silicon-upon-Avon? So as Orla mentioned, a key point on the data protection aspects of Brexit will be the European Commission's adequacy assessment of the UK. Not only will it allow for the continued free flow of personal data from the EU to the UK without needing to put in place a transfer mechanism, standard contractual clauses, which we've seen recent updates to in the last few days, binding corporate rules. Perhaps we'll see Privacy Shield Mark III, that remains to be unseen. But importantly, it would also represent recognition of the UK's data protection framework as one that can provide adequate safeguards, which is important to continue trust and confidence when it comes to privacy and the handling of personal data. That just grows day on day. So with that, I know my clients will be so interested to hear from the other panelists to the extent that they can provide insight into the current state of negotiations and the trade discussions in this context.
Very good. Thank you, Katalina. You've got a question that you can follow up later. There's one in the Q&A, and that reminds me, ladies and gentlemen, if you've come on a little bit late, if you would like to pose a question, we'll be answering those at the end of our initial round of interventions by our speakers. We do have 2 questions in there already, for which we thank you. And if you'd like to pose one, you can just pop it into the Q&A section. So that brings us to our next speaker, our 4th of 5 speakers, Mr. David Henig. David has a background working for the UK government in trade and now is in a prestigious think tank in Brussels. So we're going to go back to a little bit broader perspective, but focused on the UK and the policy and geopolitical aspects of things. David, over to you, sir.
Thanks, James. Good afternoon, and yeah, I just want to look to start with this title: Silicon Valley-upon-Avon. Can Brexit help deliver it? And I'm going to say no, Brexit can't help deliver it, but for a different reason than you might expect. Because I maintain that we already have it. The UK is actually a services superpower already, and so the question is actually not can Brexit deliver it, but can we maintain our status? Now, I'm not saying we are the best, absolutely the best at everything to do with tech, but we're pretty good actually. This is an area where the UK can, definitely say we are one of the leaders. We are a superpower in services trade. We don't often say that. Now, there's a second slightly awkward thing to say about this, which is that there is a bit of an uncertain legal framework around this. And one of the things we don't know is the degree to which the legal framework, the international trade legal framework, such as around data flows, how much that is actually going to matter. And I think that when we start to think about the UK's position and how we maintain the UK's position in tech in the future, this is going to become very interesting. I've said many times before that the UK is actually it's a trade policy experiment, Brexit, because we're going to see what happens when you remove a country from a highly integrated market. And in an area like data, how much that will make a difference, we are about to see. But before I come on back to data, I'm actually going to look at some other elements that will mean the UK answer the question: are we going to remain a strong power in tech? Because there's a number of parts to this. Actually, for me, the first one is not data at all. It's about people. we had the benefit in the UK of access to a huge labour market of young and tech-savvy individuals who wanted to come to London and the UK and make their way in the tech industry, and they could do so with no questions asked. Now, in the future, we're not going to have that. We're going to have a formal regime in which companies are going to have to sponsor people. Now, I'm not sure that is going to fit with the tech model, and that is actually almost certainly the UK's #1 challenge in retaining tech leadership is going to be about people, not about data. And the #2 is also not about data. It's about investment. It's about being open to investment. And we've got to look around and say that there are pressures for the UK to become more closed, as there are pressures around the world at the moment. And I think it's this as well. If we look at the big picture on tech and trade at the moment, it is towards more restrictions. If we actually look at what's happened this year, the big tech policy developments, we look at what's happened in the US over TikTok and ByteDance, we start to worry about whether free flows of data are going to continue. We already know that there was a problem before with China. To what extent is the EU going to allow that? To what extent is the US going to allow that? And I think, therefore, third, for the UK, if we are to retain our position or even strengthen it, we need to be the ones pushing for consistent rules and regulations, not siding with one country against another. And this is something that I think the UK government has struggled with a little bit. We need a government to understand that we need consistent global regulations that'll allow us to export globally. Insofar as that's an issue, UK companies will also try to work around regulations, and we're quite skilled at that. But to the extent we can, we should be pushing for consistent global regulations. I think we also need to make sure we're on good terms with as many markets as possible, and that means the US and the EU, where we're going to be doing a lot of sales, but it also means Japan. It is good news for the UK that we had an agreement with Japan. It remains to be seen how much the digital chapter of Japan, and the fact that differs from the EU-Japan agreement, how much that really matters, we don't know, but it's something we're going to find out. But I think we need to be on good terms. We need to be on good terms with China and India. For the UK to succeed in the future, we have to basically find our way to working in all the markets possible to us. That, I think, is a big challenge for us, particularly when with data flows, as we've seen, as I already mentioned, there are signs of restrictions on top of existing restrictions. How the UK manages that, that could actually be an opportunity for us to go beyond what we could have done within the EU, but only insofar as we manage to be able to bridge different countries, the EU, the US, the Far East, etc. And so I think that's a big challenge for us. We do need data adequacy. It is going to be a problem, or at least we think we need data adequacy. It's going to be more difficult, and I think it would restrict investment in the UK if we don't have that. But also, we can't just rely on that. So I think there is it's complex for the UK to navigate around the regulatory landscape, and at the same time, UK trade policy is relatively immature. We're new to trade policy. We're still trying to work out our positions and what it means for different groups, and what we should do. I think that we need to consider starting with partners our own services or digital plurilateral agreement with other countries, or perhaps joining the one that's already in place between New Zealand, Chile, and Singapore. Taking the initiative specifically in this area, almost as a sign of confidence and as a sign that we want to help set the rules. We don't want to get stuck into one country's model. So be aware of the challenges. So that's very much my overall thinking on this is we need to somehow be able to work around the world, work with different models of regulation, work around them, between them, within them, doing what we can. But we also need to get our own domestic policy framework right with regard to people, with regard to investment. That, in totality, is a big challenge that we've got coming up. But I think that of all the areas I've come across, of all the sectors I've come across, this is the one where I still believe there is an opportunity post-Brexit. There are fewer challenges than we've seen elsewhere. They're significant. But I think that given the UK does have a services strength, we can continue in that direction. So those are my thoughts for the time being, James.
Excellent job, David, and you've given us, thanks for the provocation also. That's always good to get thoughts moving. I was on a webinar in the recent days with a think tank across the pond over here, the Peterson Institute. We had Malcolm Turnbull, the former Prime Minister of Australia, talking about the role of the UK and perhaps some of the agreements to come, and mentioning a possible invitation to the TPP, where, of course, we have digital trade. And he was mentioning also, of course, the RCEP, which was just signed last Saturday, which also has digital trade components to it. Japan is a signatory to both of those, and you highlighted the UK-Japan agreement. So Japan seems to have a pivotal role. I think we may come back and talk about Japan here in a little bit. But let's first complete. By the way, thank you for all the questions, everyone, to our guests. We have 4 questions, so let me invite the panelists also to look at those. One of them is specific to Katalina, and the other 3 are specific to all the panelists. So let's focus on that. But before we do, let's turn to the UK tech industry, and Sabina Ciofu from Tech UK is well suited to address those issues specifically. Sabina, let's hear from you, please.
Thanks, James, and thanks to the organisers for having me. So indeed, I'm the head of EU and trade policy at Tech UK, which is the largest trade association of tech businesses in the United Kingdom. So we are following closely over the negotiations with the EU, Japan, and all the other bilateral negotiations currently on the table, with a view specifically to kind of digital trade and telecoms chapters. So I share a lot, unsurprisingly, I share a lot of the kind of optimism and pessimism that David has put on the table. And I think, indeed, we do have a lot of challenges when it comes to data flows and broader with protectionism in digital trades kind of around the world. But there are kind of, a few reasons to be optimistic about the potential that the UK has in this area, especially after kind of leaving the European Union. Of course, it depends a lot on how it will design its domestic policy and the international transfers regimes that's currently being negotiated. So the understanding is that for the time being, it will use the adequacy model of the EU to assess how other countries are transferring data or using data. But that may be tweaked, changed with time, and there still is a consultation going on the national data strategy in the UK right now. But I want to kind of focus on the specifics of the UK-Japan digital trade provisions and what they may mean for the UK's direction of travel in digital trade. Obviously, this is a rollover agreement, so a large majority of the provisions are identical to what the EU has agreed with Japan, but there are significant improvements in the digital trade chapter and a bit on mobility as well, among other things on IP provisions. So they did manage to kind of get quite a lot in a short time, and I think it does signal a bit of where the UK is kind of putting its intention and its weight in the trade negotiations. So So just to kind of highlight some of the provisions that we've seen in this agreement. So, for instance, obviously the most important one is that we have cross-border free flow of data in the UK-Japan agreement that doesn't exist in the EU-Japan agreement yet. There is a review clause there, so that may follow soon. But it's a very important commitment for the tech sector. So we are definitely glad to see that happening. There is also obviously a commitment to high standards of data protection, although, and Orla would be able to kind of talk more about this, although of course that's not the legal framework through which you transfer personal data. That will be adequacy, but that commitment is kind of important to ensure trust in the digital economy. There is a ban on data localization, including for financial services, and this will significantly reduce the barrier to entry for smaller companies in tech, and in particular in fintech, allowing them to kind of test demand and start to provide services in the Japanese market slowly without having to kind of invest in local infrastructure. Importantly, there is agreement on open government data. So that commits parties to opening government data sets in machine-readable formats. This, again, will allow kind of innovative AI companies on both sides to develop and train their products and kind of deploy them readily in each other's markets. There are elements around source code provisions to include algorithms and the protection of encryption technologies. Again, these are elements meant to kind of protect proprietary information, and parties commit not to ask for those in exchange for market access. This is not necessarily something very new, but what it does is it basically keep making that point while there is an e-commerce negotiations going on at the WTO. So the more you can have it in bilateral and regional agreements, the better. And obviously, like, the bigger barrier to digital trade is actually regulatory divergence. So the fact that we have a regulatory cooperation on emerging technology included in this trade agreement is very important to look at things like AI and kind of data and technologies coming down the line. So that is very valuable to see. And one other thing I would mention here is the kind of commitment to encourage the use of interoperable e-authentication and e-signatures. There are such commitments in a lot of trade agreements on e-signatures and paperless trading. I think what's important here is the interoperability element and kind of seeing that agenda move forward. You'd think it's done by 2020, but no, and it's still a big cost to business. There are also some improved commitments on mobility for business people, and they included computer services in there. So again, more kind of generous visa provisions, which are always welcomed by the business community. So compared to what we have with the EU, what Japan has with the EU, this does have quite a few innovations. But for the rest of the world, it's not exactly groundbreaking. It will look very similar to CPTPP provisions and to other provisions we've seen in regional agreements on digital trade. So the big novelties this year kind of happened in DEPA, as David mentioned earlier, between New Zealand, Singapore, and Chile. There's also the Digital Economy Partnership between Australia and Singapore. So there are a number of different agreements that are kind of popping up regionally that look specifically at addressing this regulatory divergence that I was talking about. So these agreements also have provisions on digital identity, on a safe and secure online environment, on the interoperability of requirements. So they kind of go further in trying to address some of these issues. But as a fully fledged, like, as a first, let's say, fully fledged digital trade chapter in a UK trade agreement, it's an important step. It's a good indication that the UK is seeking to develop similar successful kind of agreements for digital trade with other like-minded countries. And of course, we have ongoing negotiations with Australia, with New Zealand, with the US, and the UK intends to formally apply to join the CPTPP in January, with a view to potentially joining in somewhere around three years or so. So I think that the bigger thing here is that the UK does seem to want to join this group of countries that are kind of at the forefront of innovations in in digital trade that we've seen recently. And ultimately, that's where you get value from, and the fact that, you kind of have this geopolitical relations playing while also creating this regulatory cooperation spaces within the trade agreements. So I'll stop here and happy to answer questions.
Excellent, Sabina. Thank you so much. And you can tell the breadth of work that you're doing. And thank you for the insights from the UK standpoint. That's really great. Ladies and gentlemen, we've got about 6 or 7 questions and about 6 or 7 minutes. So we're going to go one by one. I'll call out a couple of our speakers for each of the questions. And if we could keep our answers to about 1 minute. But the first question comes from the International Chamber of Commerce. And I think at least Stephanie and David, perhaps you could have a go at this. I'll read the question, and then Stephanie, perhaps you could lead off. Do you believe that a greater international regulatory cooperation to address the domestic drivers of restrictions on data flows, I should say, because we're in the UK, could ever exist outside any new WTO rules that support the development of international standards in areas of regulation affecting data flows, such as privacy and cybersecurity, as well as the development of interoperability mechanisms that can bridge differences between domestic regulation and facilitate cross-border data flows? What could be the alternative? Because neither a reform or a success of the ongoing negotiations should be granted as a taken. Stephanie, David, any thoughts on that one?
Yeah,
yes.
Well, actually, I'm not very optimistic concerning the outcome of the plurilateral negotiation and the WTO, because it appears there is no consensus on this question, even though there is a consolidated text. It's very difficult, it appears, to find a consensus on restriction of data flows, because, first of all, the position of member states actually reflect what they propose in their own trade agreement. So if you take, for example, the draft provision of the EU, it's completely inoperative. Just to quote it, so there is a first provision on, cross-border data flow that should not be restricted. So that's it. You cannot restrict data flows. But then there is another provision that goes on to say that each party can adopt and maintain safeguards that is deemed appropriate to ensure the protection of personal data. So it's just an illustration on where we are today. Even the EU is trying to impose this model in trade agreement and put forward this proposal also at the WTO. It's a catch-22. It's on the other hand, we want to show we want to liberalize and not restrict cross-border data flows, but at the same time, we want to retain complete, power to impose some restrictions. And so, is it possible to discuss outside the WTO? I still do think that's the best forum to address the question. But if you look at some free trade agreements, you may see that there is room for cooperation. There are provisions on cooperation. I think the problem is actually, to put it simply, I do think it's not very realistic to reach a consensus on what should be the level of, protection of privacy, and because it's very cultural, it might be difficult. But at the same time, I do think we could discuss probably the how to reach. How can we actually maybe agree on certain standards on what should be, standard data protection. What I would like to say is that there is some in trade agreements as well. If you take the TPP, what's interesting is that there is a provision on the restriction of data flow. Parties may enable data flows, but at the same time, there is an exception you may maintain this sort of restriction, but insofar as it's to pursue a legitimate objective, that it's necessary, and there is some sort of proportionality. And we may not agree maybe on the level of protection that each member wants for themselves, but at the same time, I do think we can still pursue a discussion that this could be outside the WTO, of course. And I think that stakeholders and people, because it's a very technical issue, you can still find some sort of standard of how to maintain protection. You can retain the ability to set the level of protection that you want, but at the same time, the standard must be based on something, not science, but maybe. So I do think we should involve, negotiators should involve the right range of specialists, not trade specialists, but tech specialists. I don't know if you have ever attended the e-commerce week in Geneva, where experts discuss e-commerce and digital trade. At some point, you must recognize that you have limits. It's very, very difficult to actually agree on something which is, very technical and not very concrete. So, that's my answer. It's very difficult to foresee the way forward. But I do think we need to associate people who have, who are experts, technical experts in that.
Now, just coming briefly, James, I very much agree. I'm pessimistic on a WTO solution. And I think this answers a number of questions, of the other questions as well. This was why I'm very much of the belief that the UK and anybody else should be trying to basically find plurilaterals that basically try to find some sensible ground that just says, look, we believe in data flows. We also believe that there has to be some level of data protection, and we need something in that area. And almost certainly it's going to have to be done outside the WTO first, because I have no faith whatsoever that the WTO could agree on this issue. So I think we need to take it out of that. And frankly, I think we need to take it out of free trade agreements, where there is a danger that we're going to end up with a lot of slightly conflicting arrangements in different free trade agreements. We are far better to say, here is a bunch of principles that we agree to, whatever countries, now let's go forward with that.
Yeah, David, I think we're in the spaghetti bowl of FTA commitments.
Yeah, we don't want to be in that. We want to just get on with it.
I don't know if you can get out of it, because it's a rather broad spaghetti bowl. It's a noodle bowl as well, because it extends out to Asia. And both the EU and the United States, which are sort of the two conflicting systems, have been doing FTAs with Asia. And some of the Asian countries are agreeing with both of them. And that may be very confusing, or it may be the grounds for eventual cohesion. So I think that's going to be an interesting space to look at. Perhaps we can come back to some of that. Katalina, let's go to the second question. It was a clarification for you. Can you see that? The laws of England and Wales are geared for trade. Does that mean Scotland and Northern Ireland are less well fitted?
Yeah, thanks, James. No, not at all. And without wanting to sound like a complete southerner, just so much UK trade is focused in England and in particular in London. For example, if we think about the concentration of financial services in the city. And so for that reason, the laws of England and Wales and the English courts, and including arbitration as well, they're typically selected by businesses to govern their business terms. And for the reasons that I mentioned, so much trade, so the sheer volume and the sheer range of topics that the courts will cover here in England and Wales, it makes those laws well known, well established, they're flexible. They provide a high degree of certainty because they see these issues churned out day in, day out. And I come back to the core principle of the freedom of contract under the laws of England and Wales, which means that contracts can be interpreted in their commercial context. Okay, very good. Our third question comes from Georgetown Law Center, so let me read that out. A quick question for all panelists regarding the potential or lack thereof of data trusts for international data exchanges. Do you see this as a way forward in perhaps some sectors or overall?
So perhaps a couple of our speakers who are more data experts could address that one. Katalina, Orla? Anyone?
Sure. I can address that one. I think from an EU perspective, I don't think data trusts are going to. Sorry, I'm data as well. I don't think data trusts are going to be particularly helpful, just insofar as they're another mechanism that can be overridden in certain contexts by the state. So the whole challenge of the EU's approach is that even if you take a contractual mechanism like a binding corporate rule or a standard contractual clause or a data trust, that alone is not going to be sufficient to facilitate a data flow if there's some sort of rule of law issue or potential for law enforcement or national security access to the data in a third country. So again, here we'd be sidelining the EU from that possibility following the Schrems II judgment. And so I was kind of interested in what David had to say about, can the UK kind of muddle in between regimes here and kind of take advantage of ambiguity? And I think at the moment that's possible because, what's lacking from the EU's perspective is enforcement. There's a kind of a cat and mouse where the EU declares something to be illegal and it takes a few years for that effect to actually kick in most circumstances. But a lot of what I think the remedy here somehow is going to need to be modular, because even if you could transfer data from one state to the other, if that second state is involved in a kind of a plurilateral arrangement with two or three others, each of those other states also has to meet that same level of protection. So that's why I see that we're going to have blocks emerge here, rather than necessarily states being able to mediate in between regulatory solutions very well.
James, I think you're on mute.
Yeah, I can't hear.
I'm sorry. My apologies. I muted myself. Are data equivalence arrangements normally included in FTAs, or are they standalone agreements? And or the answer could be both. Who would like to answer that?
It can also be unilateral, right? For people dealing with data protection, I guess you don't even need any agreement. You can have a decision that recognizes equivalence.
So yeah, okay. Any other responses there? All right, let's take that one as answered. That was from the City in the University of London. Question from MLEX. So this one we'll get a couple of responses on as well. We've had a senior EU official say yesterday that there is a delay in the adequacy talks, and it will be, quote, challenging, end quote, to conclude them before the end of the year. At the same time, we've had numerous warnings that whatever the outcome of this process, it is extremely likely to be subject to a legal challenge. What do you expect to come out of this process, and how do you think it links with the broader trade talks with the UK? So who has the crystal balls?
I'm happy to take a shot at this one, James. So yes, so adequacy will be happening. The decision will be happening after there is a trade deal or not. So first we will be hearing from the negotiators on whether they've managed to conclude a trade deal. We expect the adequacy decision to follow about 2-3 weeks after that. I would take statements with a pinch of salt at this stage. I think, if there is a will, there is a way. So, if there is a deal, there will probably be a positive adequacy decision by the end of the year. If there isn't a deal, who knows? There may not be an adequacy decision at all. Yes, I agree. I think there will be a challenge in the court pretty much immediately after it's granted, if it's a positive decision. And I think what that gives everyone is about another 10 months to 1 year to figure out what to do with everything, with data flows in particular for the EU as it kind of navigates the European Court of Justice kind of decisions, but also privacy shields, its broader adequacy assessment, the review of the SECs, and so on. So yeah, I agree there will probably be a challenge, and there will have to be some decisions taken next year, and in particular a challenge for the EU to figure out how to do data flows with the rest of the world in the same time as applying GDPR.
Excellent. Thank you, Sabina. Any other thoughts or views on that one?
Yeah, I could add something. I think here, in principle, a trade deal and adequacy should be completely separate assessments. So adequacy should only focus on, an assessment of the existing legal framework, including the UK's national security provisions. And we already have two findings from the Court of Justice that the UK's national security provisions as they stand are kind of, strong indications that they're incompatible with European law. And so I completely agree that any finding of adequacy, if there is one, is likely to be subject immediately to a challenge before the courts. But in the interim, if companies wanted to rely on contractual mechanisms, that will be also, I think, on very unstable ground, given the existing judgments that we have. And so ideally here, maybe the EU would, try and find a way. But they're very much constrained by the findings of the Court of Justice, which says that the European Commission has to have a strict standard of review here when enacting adequacy assessments. And also, where we have precedent that shows that international arrangements like the EU-Canada passenger name record agreements, where there was kind of an attempt to kind of sideline the adequacy approach, where that was also redlined by the Court of Justice in a very interventionist, quite prescriptive judgment. So there's really very little margin for manoeuvre here, which is why I think it becomes difficult.
Okay, excellent.
I think sorry, James, to interject. I think another interesting point is the updated standard contractual clauses that were issued last week. And the push to get them adopted before the end of the year. Because clearly, if they are not adopted by the end of the year, then they are not going to form part of the UK GDPR. And so at the end of the transition period, in the event that there is no adequacy decision for the UK could be in a position where it doesn't have those updated standard contractual clauses to rely on because it hasn't automatically become part of UK GDPR. And I do think that the European Commission would look to avoid divergence because that is very costly for businesses.
Okay, very good. Any other thoughts on that one? Very good question. Okay, let's
I think I would just add just add to Katalina's point there, because we've had two things coming up next week. We've had a review of the SECs, but we also had the European Data Protection Board guidance on the ECJ ruling. And those two are contradictory to a large extent. The SECs, yes, the Commission is very much looking at kind of trying to make them more business friendly, trying to make them work, basically. While the Data Protection Board, and I think there's a number of other speakers who can come in on this, has a lot more prescriptive rules for how companies are supposed to basically implement that ruling. So it will be interesting to see also how that dynamic plays out in between basically the data protection authorities in Europe and the European Commission in trying to basically sort this whole conundrum out.
Excellent, excellent. All right, well, thank you for that. Let's move to the next question coming from Promontory Financial. This one will go to our data experts. And a little provocative, so that'll be fun. Data localization seems impractical as many medium to big businesses outsource a lot of their day-to-day operations across the globe, and it would cost businesses time, money, and resources to bring those operations back to the EU or perhaps to the UK. The Schrems II decision implies that businesses can either rely on an adequacy decision or use a transfer mechanism, e.g. SCCCs, BCRs, but these also require an adequacy assessment to be conducted, which also costs money. Do you think there are other practical solutions for businesses so that international transfers can continue. All right, who'd like to tackle that one? Orla,
is Orla going to go?
No, whoever wants to go first, go ahead.
I mean, just quickly before Orla goes in, I was actually going to repeat something that Orla said earlier, which is the difficulties that arise with subcontracting, sub-processing, and supply chains. So international transfers, very rarely can you look at it going from one country to one other country. Invariably, there are a whole host of different actors in different jurisdictions carrying out different processing operations that make international transfers, a complex ordeal, shall we say. I mean, I think this is a fantastic question that the author is almost answering herself, because practical solutions, I think we're all waiting for that.
Maybe if I could just add, so I agree completely that this complicates matters incredibly, but also with the point that was just made that, you can see the European Commission here is trying to open the door for data transfers to the extent possible, but that you have this kind of contradictory or very strict reading of the court's guidance or findings from the European Data Protection Boards, so the data protection authorities. And so actually there's very little, if you read the 50-odd pages of EDPB guidelines, you see that there's very little room for manoeuvre here if you think that a data transfer to a non-EU state doesn't kind of comply with the national security kind of guidelines. There's a very good, still quite lengthy, but a blog post on this by Theodore Christakis on the European Law blog for anybody interested. But, in essence, you're kind of reliant on maybe technical measures like full encryption as a kind of supplementary measure to the data transfer in order to enable data transfer. So, I would kind of agree with the conclusion that we have a de facto data localization framework in place. And of course, this will be costly and have huge implications for business. But also, it will always come from that fundamental rights rationale.
I would just add, I mean, I agree with that. Oh, sorry, Stéphanie. I would just add, because I agree that we have this a bit of a fundamental, data localization is going on. I would also, I wouldn't dare say this with a legal hat on. This is not advice of any sort, but I suspect there's rather a lot of law breaking going on with regard to data being transferred that perhaps. Or access to perhaps shouldn't be. I just have that suspicion. I have no evidence that I'm going to provide to any regulatory authorities, though.
I love that. This is, I suspect Katalina may want to jump in on that, but just to add another element to that makes, I think, the whole conversation around data localization and data flows very even more complicated, if you want. So the EU is about to publish the EU Data Governance Act. It was supposed to be published last week, this week, it's postponed to next week, which basically creates common data spaces for various sectors. So it looks at creating, common data spaces for health, for instance, or kind of other sectors of the economy, so that companies can take advantage of this open data, basically, to use to develop products and services. Now, there in a leaked version of this document, which is a proposal by the European Commission that has to go through the whole legislative process, there were actually data localization requirements in the law, so basically they required companies to have an EU establishment if they wanted to participate in this common data spaces. Of course, there's been a lot of reaction from the industry, and there's been a lot of infighting in the European Commission on these issues as well. But I think that does signal what digital sovereignty means in EU language these days, and how kind of heavily protectionist it turns out to be when we see legislative proposals. So definitely want to watch over the next months and years, I guess.
Very good. Anyone else on that question?
I just want to add that it does seem like the same stick is being applied to all types of data transfers, all types of data, all types of organizations. Whereas I would hope that we can all agree on the fact that a company that transfers their human resources data to the US because maybe senior management is centralized there, or they have their IT resources centralized in the US, is a very different type of data transfer to, say, Facebook data going to the US. And so in some ways, I think it's a shame that a more risk-based approach or more specific assessment of the data transfer can't be applied to then apply adequate safeguards to that particular transfer.
Thanks for that. And I think that's a nice segue to our last question from the audience, and that is from Mobius, inquiring perhaps an ethical measure such as for the greater good, for the global good, could be added to the criteria for data flow. In international trade agreements, there is not frequently references to ethics. And yet actually in areas such as medical supplies and critical agricultural supplies, there are certain exceptions for the greater good, for the global good, something of that nature actually. So what does our panel think about a provision of this nature?
I'm happy to kind of just jump in with a small provision here. So basically in the EU Data Governance Act that's coming out, they will have provisions around data altruism, which is exactly that, is kind of creating the framework for allowing people to kind of share their data for public good purposes. So it's been an idea circulating for a while, even before the pandemic. I think it's been accelerated by the pandemic and the need to kind of have a framework around how to do that. But definitely something that I think is on top of people's minds since the pandemic.
Okay, very good. Well, that concludes the questions from the audience. Panos and Yves Melin, we've gone a bit over time, but I think we've really had a very rich range of questions from our attendees and some very rich responses from our panel. I think given the time limits, I'll pass back over to you, but with profound thanks again to our sponsors, Reed Smith and also Citi, and profound thanks to our speakers as well. You've done an outstanding job of both presenting and queuing up the issues, as well as responding to a multitude of questions here. So thank you to all of you. Panos.
Thanks very much. This has been a very rich discussion. I mean, it made me think, it made me question things I thought I knew, and it made me realize so many things I don't know. Many thanks to our speakers, Stéphanie, Noël, Orla, Lynskey, Katalina, Bateman, David Henig, and Sabina, Ciofu. Many thanks to Lee Reed and Yves Melin, who had this idea about bringing forces together in order to discuss issues such as the one we just discussed. As I said, this is a joint initiative between Lee Reed and Jean Monnet Chair in European Union Law at City Law School. You will hear from us again. We're organizing other events, similar format. I would not like to finish without thanking very much our moderator, James Lockett, for chairing this so expertly and so elegantly. Thanks very much, everybody. This webinar has been recorded, and it will be available for a limited period of time to those who have registered. And, well, we hope to meet again soon. Thank you.